with me? Alright, let's move on. Client interviews. We've got a pretty easy night tonight in terms of we haven't got 1,000 rules. Some nights it's just rule after rule after rule, and it is a bit boring. So at least while it's not, let's enjoy it while we can. So client interview, taking instructions. So remember what we said before, that 2 of the 3 things that they'll remember is how much it's going to cost and whether they're going to win. So fairly early on, you're going to be trying, that's what you're trying to get sort of fairly quick, but you can never tell someone straight away how much it's going to cost, and you can't tell them how it's going to win straight away. So it's about trying to get enough facts quickly to give them a little bit of an idea before you go into the really detailed statements and getting all of the information, okay? And bearing in mind that when a client comes in to see you, invariably they're not going to be a lawyer, so they're not going to be giving it to you in the order and the manner in which you'd like it received, and nice and simple. It's going to be all over the place. So they're going to be jumping around, and they're going to be telling you something that happened yesterday, something that happened 10 years ago, something that happened last night, then 5 years, you're going to be going, when did it, sorry? So your aim when you get instructions from a client is to try to get an ordered timeline of what has occurred. Okay, so you're trying to get all the information that a client has in their head into yours. Okay, now I often, when I meet a client for the first time, especially if this is very new and they haven't been involved in many litigations or any before, is to let them for the first 5 or 10 minutes really just kind of go on their own tangent and do their own thing, because they've stuff they want to get out and tell you. Whether it's relevant, whether it's not, whether it's in the wrong order, whether it doesn't matter, just let them do it. Okay, so then they feel a bit better, right, got that. And remember, you're also trying to build that rapport and relationship with these people. So if you start straight away going, hang on a second, hang on, I need to know what happened back in 2000, they're going to go, what? Okay, just let them do their thing for a bit. Then when you've started a little bit, and you say, okay, well look, I just need to get a little bit better order. And I can tell you they will not have it in order, and it can take you some time for a simple matter. It still might take a few hours. For a really super detailed, complex, significant matter, taking statements can take weeks, okay? It depends on the matter. But you have to get from the very start, from when something first occurred, and sometimes even you need information prior to then to understand the background or the reasoning as to why that occurred through to now. You need that in order. Okay, and so when you're taking a formal statement, as you go through each of those events, you're going to be saying, is there an email, is there a letter, is there a note of a phone call, is there, you're going to be seeing what evidence you've got of each of those things. So that's why that very first one, when you first meet the client, you're not going to do that, because they're too anxious, they're too nervous, and they just want to give you a lot of information in a short space of time. So it kind of falls into 2 parts. You do that first part, and you can say, okay, look, we're going to need some more information, but, based on what you've told me, I think, you've got a, reasonably good chance, or, 50-50 or whatever. And I think, for that sort of a process, you can do some diagrams like I showed you. I draw my little timeline lots of times. And then say, like the average sort of cost for that would be between, whatever it might be, say 20 and 30,000 or something. And then if they're still with you, you haven't lost them because they thought it was going to cost $100 and it was all going to be over tomorrow. So if they're still with you, then it's okay, good, then we'll move on to stage 2. So stage 2 is okay, let's get the nitty gritty. Let's get what we really need, and then I can give you some good advice about really where you stand and what claims you've got, what remedies you might have, or if you're on the other side, what defences, responses, those sorts of things, and really some much more detailed information about costs. So it's a bit of a 2-part thing. But you really are trying to get as much information as you can, as if it was in your head, what's in their head is in yours. Because if you go to court, you're the one on your feet answering queries from the judge. Okay, the judge isn't asking your client what happened on that day, or what was that, or what email was that, or it's not them being asked, it's you. So you need to, from a very early point, be getting that really super detailed, and mostly the information you get from your client won't have that level of detail. You'll have the main items. It'll be up to you to fill in all those blanks. Okay. So once you've worked out that you don't have a conflict and you can act for that client, you can sit down and take the instructions, or on the phone, whatever it might be. You want to take notes. Okay. Some people take handwritten notes, some people record it, however you want to do it, but you need to take some notes as you can go away and do your statement afterwards. One of the key parts that lots of junior lawyers gets wrong, and it can be hard, is to actually work out who your client is. I know that might sound like something that's pretty silly and you think, of course I know who the client is, the person sitting in front of me. Well, sometimes it's not. Okay, so sometimes when you're dealing with entities, so it's not a human being, it can be a little bit tricky sometimes to work out who your client is. So you need to make sure you're really clear and establish who your client is. Why is that? Because that's who you're acting for. And that's who you're going to bill. And that's who you're going to, enter into an agreement with to do services for. So be really clear. It's not just the human in front of you. It's who what entity. And we'll talk more about that throughout. Sometimes even with the client, they don't know. Sometimes the client's got that many entities that they have, a number of companies, trusts, different things. They just say, oh, I don't know. It's the one that always holds the assets or something, and you're going to have to do some work. But the point is, you got to make sure you get the right one. Some of the stuff that's really, not legal based, but you need to have is all of the contact details for your clients. You want their full name. So all their names, not just their first and last, all their names and all of their contact details. So you want how to post, how to fax, if they still use a fax, email, mobile, land, everything, okay? All the information you can. There might only be one time on the file when you need it, but you will need it at some point when you're trying to find them desperately to get instructions urgently on something, and you'll wish you had written down all those other numbers they offered you at the start. Write them all down. You may need them at a later time. If it is an entity as opposed to a human, then you want to take down their ACN or ABN numbers, and you can do a search. You learn all about these things, but you can do an ASIC, so an Australian Securities Investments Commission search. So it's kind of like a driver's license for a company. So for a human, you would ask for their license to take a photocopy of. For a company, you would do a search through ASIC for the company to get their information. When you have done, so you've done that first little shorter version to give them a rough estimate on costs and whether they've got any chance or not, because sometimes they've got a hopeless case. You say, look, we can keep going if you want, but you're just going to waste your money. So they'd rather know that then than if they spent $5,000 doing a statement with you. Once you've gotten past that first point, you're going to want lots of documentation from them. Okay, because you will want to do that statement, so you'll want all the emails, all the letters, all the phone messages. There might be evidence by way of, who knows, phone records, mortgage documents, like the list is endless. Whatever information you need to evidence, you've got to start thinking early about if you're acting for a plaintiff, so someone who's making a claim, think about what evidence am I going to need to prove my client's case very early. So there's no point doing the whole statement and going, yeah, that's great. Then getting down to like the disclosure point, which is, remember that second part of the whole process. That could be a year down the track, and they say, oh no, I don't have any of the documentation. That would have been good to know 6 months ago and $15,000 ago. But so you're seeing more and more about how you're going to be thinking about things that are further down the future early on. Otherwise, you won't be able to do what you need to do when you get to that part of the process. So with their statement, you'll say, yep, I emailed him on such and such. You say, oh, great, can I have that email? You put that in the statement. Oh, I phoned so-and-so. Do you have a file note? Oh, no, but I wrote down something in my diary. Great, let's get a screenshot of that. Whatever. Move through the statement. Okay, you're getting all your documentation. You'll get given perhaps a heap of documentation from your client. It'll mostly be, prints from emails and things, so they're not something that you need to take great care of, because if you lose them, they probably have another one. But you'll also have some documents you've got to take really good care of. So you might have like a lease document or a mortgage document or a will or something that's the only document. That's it. You lose it or you put it accidentally through the shredder or something and it's gone. Okay, that's bad. So if you get anything like that, then you want to take copies of them, put the originals they gave you into your safe custody in the firm, so they're safe, so they're nothing's going to happen to them. Then you work with the photocopy of that document. Then if you want to draw on it and highlight it and different things, that's okay. But you've got the original, what you need for evidence purposes, tucked away safe, all good, no problem. Don't do a hole punch through the will and then put it on the spike and think, well, we've got our evidence. Don't touch those documents, okay? Evidence, originals, yep. And don't be led by the client about, okay, well, these are all my documents. This is what I've got. And go, oh, okay, no worries. Well, maybe they're not. Maybe they just didn't realise it. Again, think about, what do I need to prove for my client's case, or if you're on the other side, what do I need to show for my defence? And then think, to do that, what documents do I need? It might be that you need a certain financial document, which the client didn't realise you need, but yeah, they've got it if you ask, or they can get it from their bank or whatever. So don't be led by them saying, this is all I have, or there's no more. Think about what you need, not just what's in front of you, what you need to do for your case. Remember, they've come to see you for advice and assistance, not just for you to be a robot and do what they've told you. They aren't the lawyer. Okay, so they're seeing you and they think they've got everything, but they don't know. They're not a lawyer, so you need to take the reins with that. Okay, so we've done all this, and partway through we're going to talk about costs. Because can you imagine if you walked into Woolies and all of a sudden all the shelves were blank with prices? They just had all the products all over the shelves, but they didn't have any prices on anything. You'd feel a bit, awkward and a little bit anxious, wouldn't you? Like when you went up with your order as to what things are going to cost. You might think, oh, like bread's normally this or milk's normally this, so it's no big deal. But really, who knows? And all things that you don't buy very often, like maybe like you never buy, I don't know, flash steak or something. You don't know how much it's going to cost. It wouldn't feel very good not knowing. And knowing too that when you got to the checkout, like you couldn't actually take it back and not pay for it, like you had to pay for it regardless. So think about that when you're acting for a client who, when they're walking in your door, particularly if it's the first case they've ever had with a lawyer, they're going to be probably more nervous as anything about how much this is going to cost them and are they able to afford what needs to have happen. So be really mindful of that, okay? Because some of the hourly rates that we charge they're pretty high amounts. That's because it's skilled work that you need to have a lot of experience and knowledge for. So it's worth the money, but it's something that lots of people, not everybody, but some find it hard to pay for. So you need to be mindful, and you need to be really upfront then about what it's going to cost, so that they're not under any surprises. So that's what that part of the law is about. We'll have a look now at that part of the Act. So you want to have a look at part 3.4 of the Act, which starts at section 299, and it's all about making sure that lawyers are aware of what requirements they need to abide by in order to have clients that are fully aware about costs. So section 308 talks about what matters must be disclosed to a client. Now, what I'll show you early up to make it a little bit more user-friendly is these are just some very standard, not with real names, obviously, documents. So to prepare a costs agreement for your client's name in here. There's lots of information. I actually walk my clients through it so they know, you can, the whole thing is that much. You can hand it to them and say, here you go, have a look at that and sign it. And for lots of people, they'll read it. Lots are going to say, can you just tell me what it says, please? So whilst you can't tell them exactly what it says without going through it, you can walk through and you can say, this is what it means. You put in hourly rates here. So you say, this is how much we charge. So our firm, we charge per hour. Some don't, some do. So you put in here how much you charge. There's more things that you're going to be charging for. So for example, if you're charging for outlays, photocopies, different things, you put in the amounts those are going to be. So you're being upfront about what it's going to cost. If there's other outlays that you've got to pay for searches and different things, you're putting in all of those. So you're explaining the sorts of things you're going to have to pay for. If you're going to require that they pay some money up front into trust before you'll start their matter for them, you need to put this in there as well. You need to say, hey, this is how much it's going to cost. We'll need a payment of $2,000 or whatever it is up front. And I've put NA for this one, but you might have to sign them for personal guarantee. So if you're acting for a company, you might ask for a personal guarantee. You're saying how often you bill, how that's carried out. So there's lots of information through there they can read, but I like to walk through it with people to make sure they're fully aware of what it all means. It's not just a piece of paper. So that's the overview, and then, for example, this one talks about some estimates. So you'd say, I like to break mine up into stages. So rather than just say, right, the whole thing from start to finish will likely cost you between $20,000 and $30,000. Well, that seems like a lot of money for one line's worth of work, doesn't it? So I think, and because, as I said to you at the start, most matters will settle at some point in the middle. Most matters will settle somewhere along the line. So rather than saying, look, you're going to have to pay all that money, you may not. It might settle here, it might settle, different levels. So if you can break your matter up into stages and say, okay, for that stage, which will be, and you give it an idea of what that stage looks like, I think it'll be between this amount and this amount. Then for this stage, if it hasn't resolved or it hasn't been finalised at that point, and so on. So then that person can see, okay, so if I can finalise it at the mediation, it's only going to cost me $10,000 or whatever. All right, so you can give them a bit more idea if you break it up into stages. So the whole point of that is so they know how you're going to bill, how much you're going to charge per hour or per whatever, and some estimates as to costs. Then they sign it and send it back. So that's what we're talking about through these sections. When you need to disclose, so section 310 talks about when you need to disclose, and basically it's as soon as possible after receiving instructions. So sometimes you're going to be able to do it straight away. If it's a very straightforward sort of a matter that you've been instructed in, you'll be able to think, oh, yep, we've done 100 of those, this is how much it's going to cost. Sometimes if it's something a little bit out of the box, and you might need a little bit more information before, you might say to your client, look, we're going to need 3 or 4 hours worth of work, which will cost this amount of money, to work out what we need to do for you, and then etc. So it's not all straightforward. Sometimes it's a bit different. There are circumstances when you don't have to do cost disclosure. So section 311 talks about when you don't have to disclose. One of which is if the legal fees are not going to be more than $1,500. Now this is something you need to update your legislation in. So something you can take into the exam. So this is section 311 of the Legal Profession Act, and the Act still says $750, which is what it used to be many moons ago. It's $1,500. So you can put a line through that and correct that. And you'll get it wrong if it's in the exam, you put $750. I'll know you didn't show up tonight as well. So make sure you put $1,500 and put that down as your correct amount. So if you're going to have a matter where it's going to be less than $1,500, you don't need to prepare all that paperwork. So for a lot of smaller matters, they will run through without those. There's a heap of other ones when you don't need to prepare them. For example, if they've already received a statement from us in the last 12 months, if they've already received one of those cost disclosures within the last 12 months, they've already been advised as to how we charge and what it's going to be. You may not need to do one then. It might be that the client has been with you for so long and you've acted for them for so many matters that they've written to you and said, look, I don't need to have one of those every time, like you're wasting a tree every time you send it to me. It's all good. Okay, so if they've said in writing, they don't need to have it disclosed. There are a number of matters, for example, if the client is a certain type of client. So if the client is a legal practice, because they'll know about cost disclosure already. If they're a public company, if they're a foreign company, etc. There's a long list. So you can have a look at 311 as to when you don't need to disclose. Obviously, if you're doing the work for free, you don't need to disclose either because there's not going to be any cost. That's also on your list, pro bono. You might be saying, why is this really all that important? Why is it such a big deal as to how much we're going to charge? Oops, I've got a pen here. Before you go to any settlement with a client, or when an offer is made, but especially if you go to a mediation or a settlement, you're going to always want to do something like a best, a worst case, and a settlement offer scenario. I do one of these for my clients every single time. So because sometimes, and where I'm headed to is the Act makes you do one of these prior to a settlement, because when an offer is made, a client won't often understand what that offer really means in monetary terms. They may just see, so let's say that there's a claim, so say your client's made a claim for $100,000 against the other side, and an offer has come in to make payment of 50. All your client sees is that they've sacrificed half of their claim. They're saying, but I'm owed 100. Why would I accept 50 when I'm owed 100? That doesn't make sense to me. So you do one of these, and like they still might not accept the offer, but they need to fully appreciate what that offer means in terms of costs before they say yes or no. It gets even more complicated when we've got formal offers, but we'll deal with them, I think, in week 9. Let's look at this for the moment. So, okay, under the best case scenario, I'm just, these figures are out of the air, but so a best case scenario, they'll get an order from the court for their $100,000, okay, for the full amount of their claim. Best case scenario, they'll also get an order for the other side to pay their costs, okay? So let's say for a claim worth $100,000, say the order for legal fees was, say, $20,000. So the other side is paying to them $20,000 for their legal fees because they won. So that's all looking good. But they still have to pay me, okay? So because most times you'll learn all about these things. It's a bit hard in the first few lectures. You get a lot of information in a short time. But this one's probably on what's called scale. So you get ordered based on a court scale, but you have to pay me based on what our client agreement was. So mine's probably twice that. So you're going to have to pay me 40. So we got 100, we got in 20 from costs, and you've paid me 40 out of that. So your net 80 from your best case scenario. Okay, all your moons have aligned. That's the best we can do. Your worst case, they never like hearing that when they say, "Oh no, we won't lose." You might. Worst case scenario, you get 0 for your claim. You get ordered to pay the other side's costs because you lost. So now you're paying 20. So instead of them paying you 20, you're paying them 20, and you still owe me 40. Okay. So the worst case is minus 60. So I can promise you, when they had in there, here's another one of these little lines. See, I love doing these. So if this is 0, they had in their mind only this part of the line, from 0 to 100. That's what they had in their mind when they walked in. They didn't even think this negative part existed. Right? So an offer for 50 is here. They're like, no, that's halfway. That's pretty ordinary. Well, worst case is down here. So all of a sudden, that offer for 50 seems a whole lot better, doesn't it? Because it's only that far away from your best, but it's a long way away from your worst. Okay, so you need to be real. Oh, so say we worked out then for the offer. So you might so like the offer, then you get 50. They're not paying you any of your costs. And then, because we've settled and we haven't had to go to a trial, you've stopped it early. We haven't had to spend all this money. Let's say you've only spent 10 grand on fees, so you're left with 40. So our offer's here. So you need to do that sort of a scenario, and the legislation actually requires you under 312, so section 312 of the Act of the Legal Profession, requires you to do that when there's settlement happening, okay, because they haven't thought about that one. Okay, so if there's a failure to disclose, so if you don't do all of what I just said, section 316, you may be restricted to what's called scale costs, or costs under the court scale. We talk about costs another time, but basically there are two main ways costs can be assessed or paid. The first one is under the court scale, or it also can be called what's called party costs. Party costs. So you'll learn about court scales another time, and we'll show you. So the court's got a figure for everything, for a phone call, for a letter, for drafting documents, everything. Okay, that's what you normally, when you get a court-ordered amount for monies, for fees, they're normally on that. Lawyers tend to charge on what's called solicitor-owned client. Solicitor-owned client or indemnity basis, meaning on an hourly rate and all of the monies that they've paid. So that's why the amount you tend to pay to your lawyer will generally be more than what your court order will be, even if you've got all of your costs ordered. Sometimes you can get a court order on this basis, sometimes, but it's the exception rather than the rule. This is absolutely the much more common way that will happen. So there will normally be a disparity, and you need to make that very clear to your client that even if they're completely successful and win absolutely everything, they're probably still going to be out of pocket part of their costs. We learn all about that another time. But what I'm saying is if you don't do those documents I showed you, you won't be able to charge your client on this basis, on the higher basis. You'll have to charge them on the lower one over here. Have a look also at 334. So 316 to get the failure to disclose. Look at 334 onwards. It talks about all of the various outcomes as to what can occur if you don't disclose. It can even get to the point of professional misconduct. Can be, not all the time. But so what I'm outlining here is it's important. It's not something like, oh, whoops, didn't send it out. Big deal. Okay. How are we going? Everyone still good? Cans, everyone still good? Alive? Yeah. Yes. Progress reports, section 317. Clients, if they want to know, so if they think, all of a sudden they wake up and think, how much do I owe my solicitor? Maybe it's getting right out of control. If they want to phone up and find out or email, they can, 317. Have a look at 319. It talks about the recoverable costs and pretty much what I just explained here. So it's a little bit like, you know, when you do medical stuff and you go see your GP and there's like a gap between what you get back from Medicare and what you've got to pay for the doctor or the service. It's a bit like that, only bigger gap. Yeah. So this is, so the court scale, party's a bit like what you get back from Medicare, only you don't, that's the other side's paying it. This one, and this is like the full amount you've got to pay to the medical practitioner. It's that same type of thought. So what this one will be, so let's say, so you've charged your client $40,000 for the fees, and because you had an awesome lawyer that did a fantastic job for you, they've managed to get an order from the other side that the other side pay your cost on an indemnity basis. That's a big thing when you get an indemnity basis order, right? Now, what that means, does that mean you get all that $40,000 back? You might not. What it means is all costs that were reasonably incurred, okay? You're going to hear me say the word reasonable a lot. The law loves the word reasonable, and what that might mean in one situation is completely different to what's the next. It's all about what's reasonable. How long's a piece of string? Don't know. But for each one, they're going to have a look at what was reasonable. So let's say, for example, you had a client who liked to ring you every day and have a chat for half an hour about not only the case, but about, you know, the cat or the weather or whatever. They like to, but, you know, and they were more than happy to pay for your time because that's what they like to do. And you would duly charge them for half an hour every day because they'd say, look, I'm more than happy to pay for this. That's great. I love talking to you, and you do that. Should the other side have to pay because your client liked to ring up and have a chat to you every day? No. So that won't be a cost that is reasonable for the other side to pay. Okay, so whilst you will bill your client for everything you told your client you were going to charge for, it might even be, like they might even be having to talk about the cat. It might be that they just ring every day for an update. You know, we've all had those clients where they ring every day. Anything happen? I'll ring you when something happens. But they've rung every day. They keep ringing. Again, should the other side pay for that? No, they shouldn't, because that's unreasonable to have to pay for that when nothing, we'll tell you. You know, like the sun's still yellow, I'll let you know when it changes. that reasonable will be on every one, but you'll get most. So everything, so long as it's reasonable, it's not reasonable, will be taken off. So there are your two lots of amounts. That's what's talked about in 319 about what's recoverable. Security for costs, I'm going to talk about that at another time, but that's 320. Interest, 321. Interest is important. If you're going to charge interest on overdue accounts for your clients, it's something, and for some reason some people don't understand right at the beginning, you need to inform them of that before it becomes overdue. It's just like any other contract. You can't add terms to a agreement after the event. If you want to charge interest, you say to your client, here's the bill. If you don't pay within the 7 days or whatever's on there, I'm going to charge you interest. You don't wait for them to not pay and say, oh, I'm going to charge you interest now. Okay, it's got to be at the start. So have a look at interest on 321, about how you can charge and how much you can charge. Have a look at 322, talks about the agreements that I showed you, the actual written documentation. So at the end of the cost agreement, there's a form that you need to give to your clients. Hopefully I'll get it here. There we go. So this is the back page you have to include into your accounts. So you'll see it's a Form 2 under the Act. So it's a notification to the client that if they're not happy with something in the account, then they know what to do. So like it's quite regulated, you know, there's a lot to this. So they can ask for it to be itemised. So some firms don't put exactly what occurred for each amount, okay? They just put a number of things that were done and then a grand total. They can ask for an itemised bill. So they can ask you for each and every item that occurred and how much, different things. So their options, so that's under the Act. So that's 331. All right. Let's look really quickly at file maintenance, so this was a file I prepared back, here's a file I prepared earlier, so I've been lecturing in this subject now for 10 years. So this file has been around for 10 years, and this is how we used to do them back then. I still bring it in because, well, just old time's sake, but now most things we don't print anyway, and some files don't even have a folder anymore. But anyway, so some firms will still have folders and still have them looking like this. Sometimes we just have them all on the system. We don't have them printed out. If we do have it printed out, and if you do have them like this as opposed to all on your computer, then the aim with anything with your file is twofold. You've got two aims with your file. One, that if you're not there, someone else can pick up the file or can find your file on the system and can work out what's going on. Okay, so they need to be able to, your file needs to be maintained and updated with the latest of what's happening so that anybody else, so you'll have it in your head, we know that, but what if you're sick? What if all of a sudden you couldn't come into the office for that day? What if something's happened to you and you're not in there and someone else needs to handle it for your client? Someone else needs to be able to access the file and see what's going on, not, oh yeah, I haven't written file notes for the last 3 years because I thought I had it all up in my head. Okay? Everything that happens on a file, whether it's a phone call, face-to-face, of course, emails are easy because they're already typed, letters are easy because they're already typed. Anything that happens, it must be notarised in some way. That's the first part. The second part is when you're filing it on either the hard copy or on the e-copy, is that you want them in an ordered way, again, so you can find things. So you don't just chuck it all on the one file. You will separate things so they're easy to find. So you'll have, so if it's a file for litigation, you'll have something for court documents. You'll have something probably for searches. You'll have something for correspondence, research, advice. I don't know, there's a heap of different ways. Anything that you can pull out and make a separate group for so it's easier to find, you'll be thankful for, trust me. Particularly when there's nothing quite like being on your feet before the judge asks you something where, something you're thinking, I know it's in the file somewhere, and you're thinking, where? If you've got your file really beautifully organised and you can find everything, you'll be extremely grateful, okay? So there's no magic as to how it is, there's no set way it has to be. It's so that not only you can understand it, but anybody else who picks up your file can understand it if you're not in the office. Because you'll be on leave, you'll be sick, different things. So file maintenance is very important. Jurisdiction. What are we talking about when we say jurisdiction? People know what we're talking about with jurisdiction? I get to draw a cool drawing, but I don't. Let's see how I'm good at drawing Queensland. Yeah, that'll do. Yep, great. All right, so what we're looking at there are 4 central registries. Cairns, Townsville, Rockhampton, Brisbane. 4 central registries. So which city or district, so which of these, or they're the central ones, but for something, for example, like the Magistrates Court, they're all over the shop. They're everywhere, okay? So if we're working out which of those, if it's the where, okay, then that's territorial jurisdiction. Which town, which territory, okay? Which of these we're going to do. If we then, once we work out which town, so where are we actually located, and we're looking at which court, so once we've worked out we're in Cairns, clicking on the 3, once we've worked out we're in Cairns, are we in the Mags, are we in the district, are we in the Supreme, that's the subject matter jurisdiction. Okay, so 2 parts to jurisdiction. Which town or registry, territorial, and then once we work out which territory, which court, or you can do it the other way around, it doesn't matter which order you do it in, but there's 2 components to what you're working out with your jurisdiction. Okay, so they're really important because the first thing you've got to put on your court documents, and I'll bring some in next week, the first thing you need to write up in the top right-hand corner is which court, which town. Okay, so they're one of the first things you need to do. So basically what we start to learn now is, and working our way down, is all of the items you need to be able to work out. So to fill in a claim statement of claim, we're starting that now. All right, this is the first part of that. So a central registry. So any proceeding in any court, so in any of the magistrates, the district or Supreme, can be started in any central registry. So the central registries, as I said, were the Cairns, Townsville, Rocky and Brisbane. So that makes it easy. As I said, Mags has got a whole heap of others all over the place too. And you can imagine why, because they're for smaller matters and they've got a lot more jurisdictions, but we'll come up to that in a moment. Then we'll have a look at the general rule. So Rule 35. 35 is pretty important. We use 35 a bit. So if you think of it that if you're not going to use a central registry, so if you say, no, I am not going to use Cairns, Townsville, Rocky or Brisbane, then you're going to need to comply with Rule 35. So 35 sets out the links, if you like, to which area you might sue in. So